by including even the humanitarian aid activities as a target of a sanction, the United States has not allowed the regular remittances to the humanitarian aid organizations stationing in the DPRK and made it impossible for us to import Suki-related Suki cableways and equipment which are to be used for the cultural and emotional life of our people, branding them as luxury articles. At present, the world society expresses its anxiety and concern over the fact that the UN Security Council is deprived of impartiality to the prejudice of the noble mission and principle of the UN, which is stipulated in its charter, thus being reduced to a political plaything of certain states. It has now been turned to be a political tool to legitimize their arbitrary acts and high-handedness. Judging from the above mentioned, the sanctions against the DPRK imposed by the United States are the anti-DPRK criminal acts aimed at overthrowing our socialist system by isolating and stifling the DPRK, checking our economic development. These sanctions mean a flagrant violation of the UN Charter, which stipulates the respect for the state sovereignty, the principles of non-interference in internal affairs, and the peaceful settlement of disputes, etc., an inhuman massacre threatening our people's right to existence. If the acts imposing such unreasonable sanctions and the acts of individual states, including the United States, imposing their unilateral sanctions upon other states by invoking national legislation with a political purpose, if these go overlooked, more and more states, especially Asian and African states, will fall their victims, and the development of developing states shall be seriously retarded. Condemning all kinds of imposition of national legislations which infringe upon the state sovereignty by certain states like the US, obeying the international law and international organizations, the government of DPR of Korea opposes and flatly rejects them. Appreciating once again that the extraterritorial application of national legislation and the sanctions is being discussed at this ALCO session as the agenda item, we hope that ALCO will continue its study to establish a rightful international legal regime to criminalize the unjust extraterritorial application of national legislations and hold the perpetrators liable. Our delegation supports to include the extraterritorial application of the national legislation and the sanctions as the agenda item of the 54th session. Thank you.
Thank you. The next speaker is Iran. You have the floor.
Thank you, Mr. President. Bismillah ar-Rahman ar-Rahim. Mr. President, first I thank the Secretary General for his opening presentation on this item. My delegation would like to express its appreciation to the Secretariat of the ALCO for preparing the informative description on extraterritorial application of national legislation sanctions imposed against third parties, as contained in document ALCO/53/Tehran/2014/SD/S6. Iran's delegation would like to appreciate the initiative of the Secretariat for undertaking a special study entitled Unilateral and Secondary Sanctions: An International Law Perspective. The study holds special significance to the ALCO and developing countries. It comprehensively analyzes the legality of unilateral and secondary sanctions under international law. My delegation is also thankful to the Secretariat for holding the half-day special meeting on extraterritorial application of national legislation, sanctions imposed against third parties on 11 September 2013 in New Delhi, India. Mr. President, my delegation would like to reiterate the critical importance of this agenda item, especially those manifested by unilateral economic restrictions against some developing countries, which continues to unfold in various new forms. This matter is the most important since an alarming trend seems to be emerging by certain countries to defy all international norms. The concept of unilateral and secondary sanctions violates certain core principles of international law. This include the principle of sovereign equality of states and territorial integrity and its duty to cooperate, the principles of respect for the dignity of national sovereignty, the principle of self-determination of people, principle of non-use of force, principle of non-intervention into the internal and external affairs of states, the principle of peaceful settlement of international disputes, the principle of cooperation among states, and the principle of fulfilling in good faith obligations assumed under international law. These fundamental principles that regulate and govern international relations are stated in the Charter of the United Nations and the 1970 Declaration of Friendly Relations and Cooperation among States. Mr. President, the recent endeavor to establish a relationship between the condemnation of economic or political coercion and the prohibition of the threat or use of force in the context of the 1970 Declaration on Principles of Friendly Relations and the resolution on the definition of aggression indicates that many countries and international jurists are supportive of the prohibition of extreme economic sanctions. Such sanctions threaten the territorial integrity and political independence of the state and violate the principles of sovereign and territorial integrity as enshrined in Article 2, Paragraph 4 of the United Nations Charter. In this regard, it's important to mention that the United States sanctions against Iran are unprecedented. They target all the sections of the Iranian society, especially economy and trade, inter alia oil and gas, financial institutions, and transportation. These sanctions violate the principles of sovereignty and territorial integrity. Mr. President, the role of financial institutions, particularly central banks, is crucial for all countries in terms of trade and ensuring financial stability. Central banks have significant role in promoting economic development and maintaining a strong domestic financial system. Therefore, in order for central banks to work efficiently and to conduct government activities unhindered, the law of sovereign immunity was evolved, especially by granting them immunity from being sued in domestic jurisdiction of other countries. The customary international law on sovereign immunity, reinforced by the 2012 ICJ judgment on jurisdiction immunities of the state, reiterates that central banks shall not be sued before a national court. In this regard, the EU General Court and the Supreme Court of the United Kingdom have annulled the financial sanctions imposed on some Iranian financial institutions on the basis of sovereign immunity and the distinction between commercial and non-commercial governmental activities. Therefore, the financial sanctions against Iranian financial institutions are unjustifiable and violate sovereign immunity regime and need to be condemned. Such practices of imposing unilateral and secondary financial sanctions would amount to economic strangulation and defeat the purpose of the law of sovereign immunity granted to the central bank. Mr. President, the GATT-WTO system is based on principle of free trade. The system aims at establishing an international trade order that is based on the principles of non-discrimination and equal access to all the parties. Nevertheless, the intent of the United States to attain its foreign policy goals through unilateral and secondary sanctions contradicts the objectives of GATT-WTO. The secondary sanction on business establishments and financial institutions of WTO members who are trade partners of Iran is a trade restriction and also in violation of Article 11 of the GATT. The restrictions and sanctions against any WTO member in relation to trade in services are also in violation of its obligation under the schedule and violation of Article 16. The unilateral actions which impose secondary sanctions on other WTO members are also in violation of Article 23 of WTO DSU, World Trade Organization Dispute Settlement Understanding. Furthermore, extraterritorial application of national legislation poses potential danger to the progressive development of international treaty law and rule of law. Unilateral and secondary sanctions violate many bilateral treaties, such as the Algiers Accord and the Amity and Economic Relations Treaty concluded between the United States and other countries. Therefore, secondary sanctions have affected many countries' interests and should not be recognized. Mr. President, international trade plays an important role in the development of human societies, which is a basic necessity for the full realization of human rights. Therefore, any sanctions which disrupt the international trade may lead to the large-scale violation of human rights by interfering with the access of those societies to the essential commodities. It will also affect fundamental rights of citizens of not only the targeted state, but also of third states. The imposition of unilateral and secondary sanctions deprives the people of the targeted country of basic human rights and also affects their right to development and self-determination. It's also worth mentioning that secondary sanctions pose challenges to the banking sector in conducting economic transactions, which restricts the legitimate trade of medicine in Iran because of the difficulty in transfer of funds. The drug shortage caused by unilateral and secondary sanctions is affecting an estimated 6 million people. The greatest effect has been felt by persons suffering from cancer and disorders. Thus, unilateral and secondary sanctions have direct and indirect effects on the lives of the peoples and violate the human rights of the citizens of the targeted country. Mr. President, the fact that the item extraterritorial application of national legislation sanctions imposed against third parties has been on the agenda of the annual sessions of the Asian African Legal Consultative Organization from 1997 indicates the high importance the states members of this organization attach to the issue at hand. The issue deserves to be considered in a more serious manner since extraterritorial application of national legislations continues to affect all countries as well as the international trade system. We firmly believe that this item should remain on the agenda of the organization and call ALCO Secretariat to continue its deliberation on the item. I thank you, Mr. President.
Thank you. And the next speaker on the list is the representative of Republic of Korea. You have the floor, sir.
Thank you, Mr. Chairman. My delegation extended gratitude to the Secretariat for its works on this agenda item. Unilateral application of national laws entailing any encroachment upon the sovereignty of other states cannot be justified. However, unilateral application of national laws affecting the sovereignty of other states should be distinguished from the measures taken as a means of implementing the resolutions of the United Nations. Concerning the question of conformity of the UN resolutions, my delegation is of the opinion that when a resolution is adopted by an organ of the United Nations in conformity with the decision-making procedures of the UN system, its conformity must be recognized by all member states. Thank you.
Thank you. Yes. Sudan? Sudan has the floor. Yes, please, go ahead.
بسم الله الرحمن الرحيم. شكرا السيد الرئيس. أيضا السودان يشيد بتقرير السيد السكرتير العام بشأن الورقة التي تقدم بها عن العقوبات الاقتصادية الأحادية. والسودان كواحدة من الدول التي تعاني من العقوبات الاقتصادية الإحادية يدعو إلى أهمية تبني واستمرار اهتمام منظمة الألكو وتبنيها لرؤية قانونية موحدة حول العقوبات الاقتصادية الإحادية لمخالفتها لأحكام القانون الدولي وميثاق الأمم المتحدة وأيضا مواثيق المنظمات الإقليمية. ويدعو السودان أيضا أن يكون ذلك التبني بطرح هذه الرؤية أمام المنظمات الدولية والإقليمية استنادا على مخالفة هذه العقوبات لأحكام القانون الدولي واتفاقيات حقوق الإنسان ومبدأ سيادة القانون وقواعد التجارة الدولية وقواعد المعاملات المصرفية الدولية لأن تأثيرها يقع على الدول بصورة مباشرة وعلى أيضا شعوب هذه الدول. شكرا جزيلا سيد الرئيس.
Thank you, Sudan. Is there any more request for the floor? If I see none, I consider the discussion on this agenda item, extraterritorial application of national legislation, sanctions imposed against third parties, closed. In that case, ladies and gentlemen, distinguished delegates, let's move forward to the next agenda item, which is WTO as a framework agreement and code of conduct for world trade. The Deputy Secretary General will benefit us with his statement. You have the floor, sir.
Thank you. Honorable Mr. President, honorable ministers, excellencies, distinguished delegates, ladies and gentlemen. It is my pleasure to welcome you all to this important meeting on the topic WTO as a framework agreement and code of conduct for the world trade, held as part of the deliberations of the 53rd annual session of ALCO here at Tehran. The report of the Secretariat on this subject, which is contained in ALCO document S13, focuses on the 9th WTO Ministerial Conference that took place at Bali in December 2013, which adopted few landmark decisions in certain critical areas of concern to the developing world, such as food security, trade facilitation agreement, and others. Excellencies, the WTO as an institution has always had immense significance for the welfare of the people of the developing countries since it came into being in 1995. It regulates areas that are very critical for the domestic policies of its member states, such as cultural trade, intellectual property rights, trade in goods and services, trade-related investment measures, etc. Since the Doha round was first launched in 2001, the international trading system has experienced significant geoeconomic changes spurred by the increasing rate of technological innovation, particularly in large emerging economies, and the financial crisis in the developed world. Given these changing conditions, after the 8th Ministerial in 2011, WTO members decided to pursue a smaller package of select issues, as the full package of the Doha Development Agenda was not making much progress. In 2013, the issues became known as the Bali Package and included some aspects of agriculture negotiations, such as public stockholding for food security purposes, further liberalization in the administration of tariff rate quotas, trade facilitation, and a number of issues important for trade-related development and the further integration of least developed countries into the global trading system. In recent times, the issue of agricultural trade, for example, food security for developing countries, has been the main bone of contention between the developed and developing countries in the WTO Bali meeting. I am sure that we are all deeply conscious of the difficult and challenging times developing countries are passing through in the multilateral trading system. Mr. President, a major and glaring loophole created in the Uruguay rounds of agreement on agriculture to the benefit of the developed countries was the Green Box. The Green Box allows countries to provide a range of support programs in agriculture, and these supports can be provided without limits. However, the programs elaborated upon under the Green Box are those provided by developed countries. They include direct payments to producers, decoupled income support, insurance payments of various forms, and structural adjustment assistance to retiring producers or resource retirement programs. The programs that developing countries provide, that is, government purchases from producers at administered prices, though included in the Green Box, has to be counted under a country's aggregate measurement of support. If the administered price is more than the external reference price determined on the basis of 1986 to 1988 prices. The situation has created a curious paradox. The developing countries are claiming the right to do what the US and European Union have been doing all along, protecting some parts of their domestic production while simultaneously promoting the interests of their multilateral commodity traders and agribusiness firms. The anomalies in the rules that they dispute are real. Their claim to be fighting for the right to support small-scale producers and domestic food systems is an ambition shared by many developing countries, as evidenced in the proposals of the group of developing countries called the G33, the LDCs, the African group, and some of the other configurations of developing countries at the WTO. Herein lies the crux of the issue. Are the major powers of the North prepared to go along with a global trading system that puts the interests of a majority of the world's people before their own interests? There are other issues that deserve our attention as well. These include trade facilitation agreement, integration of LDCs into global trading system, duty-free, quota-free market access for LDC goods and others. The developing and poor countries want credible and balanced multilateral trading rules that would take into account their developmental concerns. Mr. President, it is my firm belief that the deliberations today offer the member states of ALCO an important opportunity to discuss these issues at length. I am equally hopeful that our distinguished delegates will rise to the occasion and use this opportunity to discuss threadbare all the problems, issues involved in solving the complex problems that are emanating from the issues identified above. With these initial remarks, I wish you all an excellent and productive deliberations. Thank you, Mr. President.
I thank the Deputy Secretary General for his informative statement, and I give the floor is open, and I give the floor to Thailand. Thailand has the floor.
Thank you, Mr. President. Allow me on behalf of the Thai delegation to take this opportunity to express our thanks to the Secretary General of ALCO and his team for the excellent work which was reflected in his report on WTO as a framework agreement and code of conduct for the world trade, as well as the presentation made earlier by the Deputy Secretary General. The report would provide very useful basis for our deliberation on this item. Thailand is pleased to see this item on our agenda once again after it was introduced for the first time in 1995, at the same time when the World Trade Organization was established. Mr. President, Thailand welcomed the achievement of the 9th World Trade Organization Ministerial Conference, which was held in Bali, Indonesia in December 2013. Therefore, it is indeed timely for us to deliberate on those landmark decisions of the Bali Ministerial Conference at this forum. Mr. President, multinational trading system is an essential framework for the world trade and the world economy. Therefore, the active participation of all WTO members, in particular the ALCO members, is vital in bringing about a truly fair and free global trading system, taking into consideration of our interests of developing and least developed countries. Mr. President, the completion of the Doha round negotiation was prolonged, with many WTO members having sought other alternatives, in particular the bilateral free trade agreement. Nonetheless, Thailand still maintains its firm belief in the rule-based multilateral trading system through the WTO. Thailand believes that the outcome of the Bali Ministerial Conference is a significant step in bringing back the charm of multilateral trading negotiation. The Bali Ministerial Conference has brought all the members with different levels of development back together for the greater cause of the Doha Development Agenda. After the meaningful works have begun, it's important that such momentum has to be maintained and translated into an action. Mr. President, Thailand views that the agreement on trade facilitation is a very important agreement which would make a tremendous contribution to the flows of world trade. The agreement also gained wide support from both business sectors and academic communities. However, the protocol relating to the agreement on trade facilitation has resulted in a deadlock due to different views of the WTO members. This has caused delay in commencing the ratification process. Thailand is very hopeful that the WTO members will be able to find a way out from this impasse at the earliest. Mr. President, Thailand is committed to the WTO trading system and has already notified its Category A commitment to the agreement on trade facilitation. The cut of red tape in international trade would help reduce trading costs and increase competitiveness. In this regard, Thailand wishes to see the agreed upon approach and timelines of the agreement, as well as other meaningful outcomes in Bali, be implemented and be met. Mr. President, in closing, Thailand very much hope that WTO members, as well as ALCO members, work together with the spirit of cooperation and trust towards the achievement of the Doha Development Agenda. I thank you, Mr. President.
Thank you. Japan has the floor.
Thank you, Mr. President. The multilateral trading system centered on WTO forms a basis of global trade and a pillar of Japan's trade policy. Japan has been committed to steadily implementing the Bali package and formulating a work program of Doha Development Agenda since the 9th WTO Ministerial Conference, which took place in Bali last December. Among other things, we placed particular importance on the Trade Facilitation Agreement